Yes, good afternoon to everybody. Sorry, good afternoon to yes. Good afternoon to everybody because it is afternoon only because good evening start from the 4 o'clock. Yes, what I said is correct. Good afternoon to everybody. Welcome to my class. That is the online class by Professor Dr. Muhammad Saib Hussain, and who is a voluntary online professor to teaching the law of insurance to the final year first semester, that is the third year first semester students. I hope that you are hearing me. If you are hearing me, just you read what I cited on the screen. Yes,
Yes, sir.
anyone? Yes, very good, very
Yes, sir.
good. Yes, we are dealing in the last class that we dealt as per the syllabus is concerned, and we dealt up to that void and unlawful conditions that we dealt it in the before last class that we dealt the condition precedent and the condition subsequent, and this class that we are going to study the vested and contingent interest. What is the vested interest and what is the contingent interest as per the section of the Transfer of Property Act? Let us see that what is the first. We see the what is the vested interest. Yes, when you come to the matter of the vested interest is concerned, it goes in this way. The Transfer of Property Act deals with the two kinds of the interest, that is vested interest and contingent interest. And where the vested interest is to be distinguished from the contingent interest, when an interest is vested, the transfer is complete. I repeat, when an interest is vested, the transfer is complete. But when the interest is contingent, the transfer depends upon a condition precedent. When the condition is fulfilled, the transfer take effect and the interest becomes vested. Yes, that means a conditional interest also later become the vested interest when the condition is fulfilled over there. That gives the sense. Let us see the definition of the vested interest. As per the section 19 of the Transfer Property Act defines vested interest as follows. Can anyone could read what is cited under section 19? Yes, anyone?
So, Section 19 of Transfer of Property Act defines
Yes,
vested
yes,
interest as follows: where on a transfer of property, an interest therein is created in favor of a person without specifying the time when it is to take effect, or in terms specifying that it is to take effect forthwith or on the happening of an event which must happen. Such interest is vested unless a contrary intention appears from the terms of the transfer.
yes. That is the point. But if there is the quotation is there, when the quotation is there, then you should say that I quote, where on a transfer of property, an interest therein is created in favor of a person without specifying the time what is to take effect, or in terms of the specifying that is to take effect forthwith, or on the happening of an event which must happen, such interest is vested unless a contrary intention appears from the terms of the transfer. I unquote. So that was the style of writing. So that means there is certain happening would be there. That happening is a must. It may happen, but when it is happen, it will not be known. But it may happen over there. So at that instance, we can say the vested interest is there. So a vested interest is not defeated by the death of the transferee, because suppose the vested interest is there and the death of the transferee is there before he obtains the position, it cannot be defeated. That is the reason we say when we say the distinction between the vested interest and the contingent interest, we say the vested interest is transferable and heritable. Where the contingent interest is it is not transferable but heritable or depends upon the nature of the transfer is concerned. That we will study in the next part in this class only. Let us see the explanation. What is the explanation given over here? An intention that an interest shall not be vested is not to be inferred merely from a provision whereby the enjoyment thereof is postponed, or whereby a prior interest in the same property is given or reserved to some other person, or where income arising from the property is directed to be accumulated until the time of the enjoyment arrives, or from a provision that if a particular event shall happen, the interest shall pass to another person. If you read just an explanation in that way, that we could not follow it unless until we see the illustration. Let us see the illustration how it goes over there. And please concentrate on the illustration. I will read it, then I will explain you. A Hindu widow. What is the faith? I mean the religion. A Hindu widow. Widow means husband died. Adopted a son. Yes, adoption is there, a son. But there is an agreement which postpones the son's estate during the lifetime of the widow. That means the son, the adopted son, will definitely will get the transfer of the property, but when the widow's lifetime, he will not get. After the death of the widow only, that son will get, that is the adopted son, the property in the form of a split successionist. That what we studied in the section 6 and exception 1. Here, an interest created in favor of the adopted son is vested right. At that instance, definitely the widow will die, if not today or tomorrow. That means an untoward incident definitely is going to happen in the future. But once the event happened over there, then automatically the son will get the vested interest. And here, again, when the son is a minor, at that time he could not enjoy the property, but till he completion of the majority is concerned, that is 18 years, up to that extent, the vested interest is beginning would be there, but he can enjoy the property only after the 18 years later. Here, an interest created in favor of the adopted son is vested right, which does not depend upon the condition precedent. For example, performance of any act is not to take effect on happening of the event, which is certain, that is the death of a widow. So a death of the widow is certain would be there. Then after the death of the widow only the vested interest would be their son. If the son, adopted son, is having the more than 18 years over there, then vested interest automatically will be there. There he can enjoy the property also. But when he is a minor, he could not enjoy the property, but the property is vested on him. But such property, if he wants, he can transfer also. Of course, for the transfer, there should be a guardian consent would be there when the son is a minor. The adopted son has a present proprietary right in the state. Yes, the right of the possession and enjoyment being deferred. Of course, he cannot enjoy the property, but he can possess the property that will be deferred, and therefore he can transfer the property even during the widow's lifetime. Even during the widow's lifetime also, he can transfer the property. But similarly, a transfer in favor of a person simply creates a vested interest with an immediate right to the possession and enjoyment of the property. Such vested interest is not defeated by the death of the transferee, even before getting the possession of the property. Suppose before the death of the widow, if the son, adopted son, is died, then it is not, but still it will be heritable. But if any other legal heirs are there, if any other person will be there next to the son, and they will inherit the property through the inheritance itself. Of course, if the adopted son is say, the adopted son generally, the son may be not more than 18 years, and such son cannot be adopted. Only the limitation period would be there. The son will be adopted is a minor, number one. Number two, it should be a sibling, means is a still a suckling baby would be there. So no one can adopt a 18 years old son or daughter. So that is the limitation would be there. So let us see the another illustration so that we could understand what is the total crux of this section 19, that is the vested interest in the Transfer of Property Act. It transfers A, transfer the property to B. Good. A is the owner of the property, and he transfers the property to B. As per the section 6 is concerned, any property can be transferred, except they say section exception is small a to small I with double D is another, is total 10 would be there. It transfers the property to B, good, in trust, yes, for C. So he transfers the property to B in trust for C purposes, and direct B to give possession of the property to C when C attains the age of 25 years. So he said, you take this property, but you transfer the property and give the possession of the property when C attains the age of 25 years. So now the question comes over here. At that time, after 18, first the property will be vested immediately, but he can enjoy the property only after the 18 years are concerned. In this problem, the enjoyment in the property is postponed, but this does not prevent the interest vesting immediately, but such transfer itself is void when C attains the majority. So now the question comes over there. If you keep the more period, then the majority and such transfer will be void, because as soon as the son or C will get the age of 18 years, then immediately that he can enjoy the property, he can transfer the property. But the vested interest comes at that instant only when he attains the 18 years. That is the point. But the more than 18 years would be given over there. At that instance, that will be the wrong transfer would be there. Transfer itself is void when C attains the C attains the majority, because the majority at the time only that he has to enjoy the property, but not we cannot extend to the longer period. Therefore, C has vested interest and entitled to the position of the property at the age of 18. That means at the age of the 18 only the property will be vested to him, and where he can dispose the property or enjoy the property. But the condition is put it over there for 25 years. Then such a transfer itself is a void. It says. So this is the one case law there we can say that if we could keep the limit of the enjoyment of the property more than the 18 years, such a transfer should be there beginning to right, because the enjoyment will come only after the 18 years when the C becomes. That's the point. Any doubt? Yes, we can ask me. If there is no doubt, you can say that, sir, you can proceed. Anyone?
సార్ కొంచెం ఒక్కసారి తెలుగులో
See, no, if Telugu would be there, no, that you never learn the English. That's the point. Here, what they said, I repeat it. I repeat. A person transfers the property to be good in trust. Of course, a person will transfer in the trust only. If the trust is not there, he will not transfer. Yes, be in trust for C purposes. And direct B, what he directs B to give the position of the property to C when C attains the age of 25 years. So you give the property to the C at that instant when the C attains the age of 25 years. So in this problem, the enjoyment in the property is postponed because he is a child, he could not know what is the nature of the property, how it could be handled. So that's the reason. So in this problem, the enjoyment in the property is postponed, but this does not prevent the interest vesting immediately, but such a transfer itself is void when C attains the majority. The point over here is any person who will get the property, or any person who is going to where the property is transferred to him, the only condition is he can hold the property up to, means a person before transferring, he will hold the property till the C attains the age of 18. Suppose if he holds the property, even he crosses the 18 also, such a transfer is said to be the void transfer. So it's postponed. This does not prevent the vested interest immediately, but such transfer is itself void when C attains the majority. Because as soon as the C attains the majority, that vested interest comes to the C immediately. But if you could keep the condition in such a way which will be extended more than the 18 years, such a transfer is void. They say. Therefore, C has vested interest and entitled to a position of the property at the age of 18. At the 18 years only that he is vested interest, and he vested interest as well as he is entitled to the position of the property. But if any person prolong it, that transfer is a void, they said. Let us see the another illustration so that you could have a firm idea of it. Let us see where A executed a gift deed in favor of B. So it is a gift deed. So a gift deed is in the favor of B. Whenever the gift is there, naturally, unconditionally, the gift should be given. Whenever the gift is there, the position should be given. Either it is a movable property, the movable property position should be given. It is a movable property, that property should be transferred in the form of a sale deed, in the form of a gift deed. Of course, following the procedure which is laid down in the Registration Act with the stamp duty and the 2 witnesses and the land registrar, that is the house registrar or land registrar or sub registrar, whoever may be having the competent authority to make the registration. So here, where A executed a gift deed in favor of B, okay, but directed that he directed the B, but B was not to take possession of a portion of the property until after the death of A and A's wife. But he said, yes, it is given in the favor of B, but he was not to take the position of such a portion of the property until after the death of A. Number one, A should have to die it, then only the gift deed will be valid, and A's wife. So A and A's wife still they are alive, he could not enjoy the property. But that is the condition they put it over there. The portion of the property until after the death of A's and A's wife. So he can enjoy the property only at the death of A or A's wife. Take the position of the property. In such a case, B has a vested interest, enjoyment only being postponed. He is having the vested interest, definitely B. But enjoying will be postponed until the happening of an event. That means, in this case, death of A and A's wife, which is certain. So one day they are going to die. So it's a certain. Then they can only enjoyment is he can make it out. He can make it out only after the death of it. But up to B has a vested interest and enjoy only he is having the vested interest, but he cannot transfer it in one way in another way. But he is having the vested interest as soon as the gift is in favor of B. But he can enjoy only being postponed. The enjoyment is postponed until the happening of an event. What is the happening of an event? The condition is either the death of the A and A's wife. That is in this case, death of A and A's wife, which is certain. So when the vested interest will be created in this case now, in this example. Yes, anyone?
When the case and A and A's wife death.
He can enjoy the property only when the A's death and A's wife death. But vested interest starts from
18 years after.
After A's death, sir.
no. See, I repeat, where A executed a gift. Executed a gift means he has written a gift deed in favor of B. B కి చేశాడు గిఫ్ట్ డీడ్. బట్ ఎస్ ఎస్ మీరు మ్యూట్ బయట వినబడుతున్నాయి శబ్దాలు. ఓకే ఐ మ్యూటెడ్ ఇట్ రైట్. సో నౌ వెరీ ఏజ్ ఎగ్జిక్యూటెడ్ ఏ గిఫ్ట్, ఒక గిఫ్ట్ ఇచ్చాడు ఎగ్జిక్యూట్ డీడ్ ప్రకారం ఇన్ ఫేవర్ ఆఫ్ బి. బికి ఇచ్చేసాడు గిఫ్ట్. ఓకే, the date is there and so thing there. When the gift deed is there, naturally the gift deed should be registered because to avoid the legal complications later. కానీ ఏం చేశాడు అక్కడ? బట్ డైరెక్టెడ్ దట్ ఒక కండిషన్ పెట్టాడు రైడర్, ఒక కండిషన్ పెట్టాడు. ఏమని పెట్టాడు? దట్ బి వాజ్ నాట్ టు టేక్ ద పొజిషన్ ఆఫ్ ది పోర్షన్ ఆఫ్ ది ప్రాపర్టీ. He should not supposed to take the whatever the gift deed is given the position of the portion of the property అని తీసుకోవద్దు. సపోజ్ he is having the lot of land or houses, anything. So some of the part 1/4 is given to the B. That is in the favor of the gift deed. That 1/4 portion of the property he should not possess it until ఎప్పుడు? After the death of A and A's wife. So the condition they put is there. Only he can enjoy the property of taking the position of that portion only after the death of A's and A's wife. Okay, good. He can enjoy only after the A's and A's wife. Okay. In such a case, in such a situation and such a scenario, B has a vested interest. ఎప్పుడు? As soon as the gift deed is registered in his favor. B has a vested interest as soon as the gift deed is made in his favor. But enjoyment only being postponed. Means taking the position of a portion of the land which is given in the form of a gift deed to B by A is being postponed ఎప్పటి వరకు? Until the happening of an event. What event? Yes, what event?
A and A's wife death.
That is A's death and A's wife death. ఇప్పుడు వెస్టెడ్ ఇంట్రెస్ట్ ఎప్పుడు వచ్చింది బీకి?
సార్ ఇప్పుడు A and A's wife డెత్ తర్వాత రిజిస్టర్ అయ్యాక
ఎంజాయ్మెంట్ he can make it out.
ఓకే సార్, అలాంటప్పుడు ఇది ఎప్పుడైతే గిఫ్ట్ ఇచ్చారో అప్పుడు రిజిస్టర్ అయినప్పుడు
ఎప్పుడైతే గిఫ్ట్ డీడ్ రిజిస్టర్ చేశాడో ఆ డేట్ నుండి వెస్టెడ్ ఇంట్రెస్ట్ ఉన్నది. కానీ ఎంజాయ్మెంట్ అండ్ ద పొజిషన్ ఆఫ్ ది ప్రాపర్టీ he will do it only the condition fulfilled. What is the condition in this illustration? The condition is A's death and A's wife death. అది సంగతి.
అర్థమైంది సార్.
Is it clear? Now,
yes,
now we'll see what about the unborn person acquires the vested interest and transfer of his benefit in section 20. చూద్దాం ఇది. Where on a transfer of property, okay, transfer, an interest therein is created for the benefit of a person not then living. He acquires upon his birth unless a contrary intention appears from the terms of the transfer. A vested interest, although he may not be entitled to the enjoyment thereof immediately on his birth. So, ఎప్పుడైతే ట్రాన్స్ఫర్ చేయతారో vested interest from the day of conceiving till the day of his delivery. As soon as he delivered a boy or a girl, means she has delivered a boy or a girl and viable బతికున్నాడు, from that date onwards the vested interest will come to the boy, but he can enjoy the property only after the completion of 18 years. Let us see what is, we will see it in the next example. We have a separate point on the unborn child, how a unborn child will get the property. We will see it. Now we will see what is the characteristic of vested interest. Unborn child, just I have given the one example, but we will see in detail later. Unborn child, how the transfer will be take place. Directly you cannot transfer the property to the unborn child. There is a lifetime somebody should be there. Then after his life, then it is given to the next to his father. When the father takes it from the person, one lifetime he should died over there, but the father should be alive when he is conceived. When he conceived, yes, how he will conceive without the father? Father should have to make it out to conceive the mother. Then only that would be existence. So from that date till the delivery of it, but after the delivery of it, vested interest comes to him after the delivery, provided he should be alive, and then he can enjoy the property only after the completion of 18 years. But vested interest start from the day of the delivery. Of course, some people say in the gestation period also he is on the vested right. But let me see the in detail later part. But now we are making the preliminary study here. So now the characteristic of a vested interest will let us see. So vested interest does not depend upon the fulfillment of a condition. So fulfillment వాళ్ళు చచ్చిపోయినరా అండి పైన ఎగ్జాంపుల్ లా
No, sir.
కాకపోతే వెస్టెడ్ ఇంట్రెస్ట్ వచ్చింది ఆయనకు
వస్తుంది సార్.
వస్తుంది. ఎందుకు వస్తుంది? ఎగ్జిక్యూటివ్ ఫేవర్ గిఫ్ట్ డీడ్ చేసినప్పుడే వచ్చేస్తుంది. కాబట్టి ఏమంటాడు? వెస్టెడ్ ఇంట్రెస్ట్ డస్ నాట్ డిపెండ్, అది డిపెండ్ కాదు ఏది అపాన్ ద ఫుల్ఫిల్మెంట్ ఆఫ్ ఏ కండిషన్. ఏ కండిషన్?
Yes, sir.
ఏస్ ఆర్ ఏస్ డెత్
Present.
కండిషన్. So
Yes,
in the
sir.
above example, it creates a present and immediate right, through the enjoyment may be postponed to future date. It creates means the vested right will be created as soon as the deed is made and registered, but the enjoyment of the property will be postponed to future date till C attains the age of 18 years. The above example. Is it clear?
Yes, sir.
Now we will see the second point. A vested interest is not defeated with the death of the transferee. Suppose transferee death అయిందనుకోండి, పొజిషన్ రాలే, ఎంజాయ్మెంట్ చేయలే, then it will pass on to his heirs. సార్ చిన్నపిల్లగానికి హెయిర్స్ ఎక్కడ ఉంటారు సార్? చిన్నపిల్లగానికి ఉండరు హెయిర్స్. సపోజ్ డెత్ అయింది అనుకుందాం, ఆ ఒక్కడే అబ్బాయి అనుకున్నాం, కాబట్టి ఏంటంటే ఎవరు లేరు అనుకుందాం, కాబట్టి what will happen? It will revert back to the transferor. Okay, we'll see it, don't worry, we'll see it. But what I want to say is, no, if a transferee dies, then it will be transferred to the heritable and transferable. Both the things will be there for the vested interest. Before obtaining the position, it will pass on to his heirs. వాళ్ళ హెయిర్స్కి వెళ్ళిపోతుంది. ఎవరి హెయిర్స్కి వెళ్ళిపోతుందండి?
ట్రాన్స్ఫరర్ హెయిర్స్.
ట్రాన్స్ఫరర్ హెయిర్స్ కి పోతుందా? ట్రాన్స్ఫరీ హెయిర్స్
అంటే ట్రాన్స్ఫరీ హెయిర్స్ కి పోతుంది. ఎవరు లేకపోతే అప్పుడు
ఎవరు లేకపోతే ట్రాన్స్ఫరీ హెయిర్స్ ఎవరు లేకపోతే ఇట్ రివర్ట్ బ్యాక్ టు ద ట్రాన్స్ఫరర్.
Yes, sir.
Yes. Now third point, vested interest is transferable and heritable. సో వెస్టెడ్ ఇంట్రెస్ట్ ఎప్పుడైనా సరే ట్రాన్స్ఫరబుల్ అవుతుంది, హెరిటబుల్ అవుతుంది. హెరిటబుల్ ఎట్లయితుంది? సపోజ్ ద విల్ వితౌట్ ఎ విల్, వాట్ ఎవర్ ద సక్సెషన్ విల్ టేక్ ప్లేస్, a person will inherit the property. Suppose father died, propositous, then mother is there, only one son is there. After the mother's death, the property goes to whom? Son. His only one heir would be there, hence it's go to the son. The different is there. For instance, ascendants are there. Suppose propositor father is there, depending upon how much the share should go to the father, either the Muslim law is concerned or the Christian law is concerned, the Hindu law is concerned, it is specifically mentioned in the Indian Succession Act. If the will is there, of course the will should be followed over there. So that is the way we can met. So what I want to say is vested interest is transferable and heritable. So case law letter you will see it. Sundar Bibi versus Rajendra Narayan, that is the AR 1925. ALL అంటే ఏందండి ఇది చెప్పాలా?
గుర్తులే సార్.
ఆ, ఇది
మొన్న చెప్పారు
సైటేషన్
మీరు.
అంటారు. సుందర్ బీబీ వర్సెస్ రాజేంద్ర నారాయణ, ఏఆర్ అంటే ఆల్ ఇండియా రిపోర్టర్ 1925 ఇయర్, అండ్ అలహాబాద్ ALL అంటే అలహాబాద్ 389 హైకోర్ట్, హైదరాబాద్ హైకోర్ట్ 389 పేజీలో ఈ కేసులా ఉన్నది. అది అర్థం అక్కడ, దాన్ని సైటేషన్ అంటారు. సో ఇన్ దిస్ కేస్ ద అలహాబాద్ హైకోర్ట్ held that in a vested interest, the title passes absolutely from the transferor to the transferee. Absolutely, it will passes to the transferee at the date of the transfer. ఏదైతే డేట్ అయితే ట్రాన్స్ఫర్ అవుతుందో అప్పుడే వెస్టెడ్ ఇంట్రెస్ట్ బిగిన్ అవుతుంది. కాకపోతే ఏంటంటే ఎంజాయ్మెంట్ ఓన్లీ పోస్ట్పోన్ టు ద ఫ్యూచర్ till she attains the age of majority. Suppose more years are put it over there, then such a transfer is void. So though the enjoyment may be postponed, the enjoyment of the property, the possession of the property will be postponed later part only, but the vested interest comes as soon as the deed is transferred and the registered on the day. From that date onwards, the vested interest start. So it is heritable and transferable. So that is decided in the Sundar BB versus Rajendra Narayana case law. Let us see the another case law. That is, read the case law name, please.
రాజేష్ కాంతారాయ్ వర్సెస్ శ్రీమతి సునీతా దేవి.
Because it is a Calcutta case. The Calcutta law V undadu kabatti B rasindu day B. Like there is no V in the Calcutta side. There is only B. That's why they don't call Ravindranath Tagore. They will say Rabindranath Tagore. So this is the Rajesh Kanta Roy versus Srimati Sunita Devi actually. But there is no V. They say Devi. AR 1957 ante All India Reporter 1957 case law. SC ante Supreme Court decision. Means Supreme Court of India decision, and it is the report Supreme Court law 255 page lo unnadi. Now let us see what are the facts of the case law. One Ramanikanta Roy ఎక్కడ ఉంటారండి? కలకత్తా, బెంగాల్. నో కోల్కతా, ఇప్పుడు బెంగాల్. బెంగాల్ ఏం తింటారండి ఎక్కువ?
రసగుల్లాలు తింటారండి.
ఓకే, రసగుల్లా తింటారు. ఇంకేం తింటారండి?
ఆల్ ఇండియాలో ఎవరెవరు తింటారో మొత్తం తింటారు సార్.
చేపలు ఎక్కువ తింటారండి. దట్స్ వై దే ఆర్ వెరీ మచ్ జీనియస్. వాళ్ళ కళ్ళు కూడా బాగుంటాయి, మెదడు కూడా బాగుంటది. కాకపోతే ఏంటంటే కోడి కూరలో కూడా చక్కెర వేసుకుంటారు, బెల్లం వేసుకుంటారు. విన్నారా అండి?
ఎప్పుడు వినలేదు సార్.
అదే ఇది కోర్స్ అవుట్లైన్ ఉన్నదా అండి? ఇది లాఫ్ ఇన్సూరెన్స్ లో ఉన్నదా ఈ కోర్స్ అవుట్లైన్ లో వాళ్ళు బెల్లంతో తిన్నారండి?
లేదు సార్,
general topic, because my friend is there in every curry. I say, why do you add? No, that is our custom, because we will put some sugar or jaggery in it. అరే ప్రతి కూరలో, ఎస్ ప్రతి కూరలో వేసుకుంటారంట వాళ్ళు. అరే చేపలల్లా చేపలు కూడా వేసుకుంటారంట. ఎనీవే దట్ ఈస్
సార్ పటిక బెల్లం తింటారు సార్.
ఓకే. ఎనీవే దట్ వన్. ఎస్ ఐ అడ్మిట్ ఇట్. కాకపోతే పొద్దుగాల వాళ్ళ టిఫిన్ తెలుసా అండి? ఏం తింటారు టిఫిన్? జిలేబీ ప్లస్ మిల్క్. ఆర్ యూ ఫాలోయింగ్ మీ? సార్ మేము ఇక్కడనే పుట్టినాం, ఇక్కడనే పెరిగినాం సార్, కలకత్తా పోలే ఎప్పుడు. ప్లీజ్ గో, బికాస్ దెర్ ఇస్ నో ఎడ్యుకేషనల్ టూర్ ఇన్ యువర్ కాలేజ్. అదర్వైజ్ యూ వుడ్ హావ్ టు మేక్ ఎవ్రీ ఇయర్ one educational tour in any one part of the country where we can see the high courts of the different place, including the Supreme Court of India. Yes, come to the point is, one Ramanikanta Roy executed a registered trust deed in respect of his properties. Okay, executor registered deed చేసి trust deed in respect of his properties. The eldest son Rajesh was appointed the sole trustee to hold the properties and the trust subject to certain powers and obligation. So a trustee, their elder son will be given over there as a trustee. He made it. After his death, his two sons Rajesh and Ramendra, whose death after Rajesh After his death, his two sons Rajesh and Ramendra got interest in the property. Okay, the ఇద్దరు eldest son తర్వాత వీళ్ళకు ఇద్దరు సన్లు ఉన్నారు కాబట్టి the property is that after death is the sons will get the property. Okay, there was a clause in the trust deed that both of them was to get interest in the properties allotted each other happening of the two events. అయితే ఇవి ఇద్దరు ఎప్పుడైతే ఒక టూ ఈవెంట్స్ హ్యాపెనింగ్ అయితేనే ఇది దొరుకుతాయి, ఇవి లేకుండా దొరకవు. వాట్ ఆర్ ద టూ థింగ్స్? ఎస్, టూ ఈవెంట్స్. లెట్ us see. Number one, discharge all the debts. Discharge of all the debts specified in the schedule and death of the settler himself. అంటే ప్రపోజిటస్ ఎవరైతే చేశారో వాళ్ళ మొత్తం డెట్స్ క్లియర్ చేయాలా. ఎవరు? సెట్లర్. ఇక్కడ ప్రపోజిటస్ అంటే ఇప్పుడు సెట్లర్ అంటే ఏ పర్సన్ హూ క్రియేట్స్ ద ట్రస్ట్, సెట్లర్ అంటారు వాళ్ళు. సో ద సెట్లర్స్ who has created the trust debts all should be cleared over there. That is one of the condition. Next condition ఏంది? The trust was to come to an end on the death of the settler and the son was to get proprietary allotted to them after. అయితే ట్రస్ట్ వాజ్ టు కమ్ టు ఎండ్ ఆన్ ద డెత్ ఆఫ్ ది సెటిలర్. ఎవరైతే సెటిలర్ ఉన్నారో వాళ్ళు డెత్ అయిన తర్వాత వస్తుంది. దెన్ ద సన్ వాజ్ టు గెట్ ద proprietary allotted to them thereafter. If the once the settler is over, then automatically the elder son will become the proprietor of the property. The issue before the court was whether the interest created by the trust was vested or contingent. ఇది vested interest ఆ contingent interest ఆ? డెత్ అనేది డెఫినెట్ కాబట్టి can we say the vested interest or contingent interest? Yes. See, when the event is definite, we will say vested. When the interest is, when the condition is may happen, may not happen, that is a contingent.
అది listed, sir.
Now we will see. The Supreme Court held that the interest taken by the two brothers under the trust deed was vested, not contingent, because it was a certain event. Which is a certain event?
Death.
Death is a certain event because the settler one day definitely will die. At that instance, if the vested right starts over there, but once the settler is over, means elder son is over, whatever the condition is fulfilled over there, then after that conditions, then automatically they will become the proprietor of that property. Trust. Yes, vested interest does depend upon the fulfillment of a condition that takes effect from the date of the transfer. So, the vested interest applies from the date of the transfer. So, they are getting the vested interest, the two children, but only the waiting till the death of the settler. Yeah, in vested interest, there is a present, immediate right, even if the enjoyment is postponed. Definitely, they will have the legal right, but only the thing is they cannot enjoy the property. The enjoyment of the property is postponed till the event takes place. A vested interest is heritable, yes, and transferable. Yes, if the one of the fellow died, then suppose the two sons are, one fellow died, so another survivor will get the entire property because the son doesn't have any legal heirs at that instance. So a vested interest is heritable and transferable. A contingent interest depends solely upon the fulfillment of the condition. It may happen or may not happen. Contingent interest is, it may happen or may not happen. So, in contingent interest, there is no present right. There is a promise to give right upon the fulfillment of a condition. A contingent interest is inalienable. So, a contingent interest, one cannot sell it. It is not disposable. It cannot be transferred and not transferable. Means, we cannot transfer it, we cannot inherit it. Of course, inalienable here in the sense, it cannot be transferred and are not transferable. In one way, in another way, heritable also. But sometimes it is heritable depending upon the nature of the transfer is concerned. అరే నేను రేపు నీకు ఈ పైసలు ఇస్తా, రేపు అనేది వస్తుందా రాదండి?
వస్తుంది సార్.
డెఫినెట్ అది. Because when a thing is a definite, yes, vested interest start the time when he transferred the property. But when it is realized, enjoyment of the property, he could do it only from day after tomorrow, after getting the possession of it. So this is the generally what we say about the vested interest. So any other questions that you would like to ask me regarding the vested interest, then I can make it out. If not, we will see what is the contingent, because still we do have in our hand 9 minutes, because I started the 3:15. Now I'll end exactly with the 3, 4 o'clock. Yes, any doubt? Because it's saying you plug the thing. Yes, meanwhile, yeah, before I plug it, you can ask me if you have any doubt so that I could clear it. Yes,
సార్ నాకే డౌట్ లేదు.
yes, other people. Then can you give me the explanation or example for the vested interest? Yes, yes, speak. I am hearing. I am hearing you. So vested interest, when it comes, the point is a a thing should have to happen that is going to happen definitely. So when that thing is going to happen definitely, then the day when it is transferred, the vested interest start over there. But a person will enjoy, means a transferee can enjoy the property only after the getting the position of it. Suppose if he is a minor, then attaining the age of 18 that he enjoy the property. Or if any event is going to happen sooner or later, if death of a so and so person, at that time only he will enjoy the property. But as soon as he transferred it from that date or from that time onwards, the vested interest would be there on the transferee. But he can enjoy the property only when the event is over. Suppose in the one of the example we cited, A's death or A's wife death. After A's death and A's wife death only he can enjoy the property. But the vested interest comes when the deed is executed from the date. So that was the thing which will come across in this case now. And let us throw what is the contingent interest that I will give the introduction, because still we do have the 7 minutes in our hand. Up to 7 minutes we will show you, and regarding the TP Act is concerned. So we have covered the meaning and concept of property and kinds of property, transfer of property, transferable and non-transferable property, that is the section 6, and who can transfer, and that means competency of the transfer, and operation of the transfer means the legal incidents of the transfer, and the mode of transfer, how a mode will be there, and a conditional transfer. We studied the section 25 to section 34 of the Transfer Property Act, and where we studied the section 10, if I not be mistaken, void and unlawful conditions, and condition precedent and condition subsequent, which is before and which is subsequent. These conditions also we studied over there, and today in this class that we throw light on the vested interest. Then still we do have some 6 minutes with us. Then we'll see the contingent interest. Then what is the transfer of unborn person, we'll in detail tomorrow we'll make it out. So every day that my class is 3:15 to 4 o'clock, and I need not to make a reminder, but some of the students, they said, sir, we did not know it whether you take the class or not. If the rain rains, if the thunderstorms also comes, if the volcanoes are also there, if any natural calamity also there, my class is there, unless until there is no power cut in my place. Of course, we have the inverter. We can run the show with the inverter. Sir, inverter untagane ayipoyinda sir, Wi-Fi undadda sir. Do you think that I am mad enough? I already kept the dongle. So if the Wi-Fi is not there, I run the show with the dongle. సార్ మీరు ఎటైనా వదిలిపెట్టేటట్టు ఉండరు కదా. వదిలిపెట్టాను, ఎందుకంటే వదిలిపెడితే నాకు అన్నం అరగదు. Is it clear?
సార్
Is it clear?
Because you are rich, sir.
Sir? Yes, sir.
Because you are very rich.
సార్ మిమ్మల్ని మేము వదిలిపెట్టాం సార్.
థ్యాంక్ యూ వెరీ మచ్, థ్యాంక్ యూ వెరీ మచ్. దీన్ని ఏమంటారంటే సరే డౌ టైల్ జాయింట్ అంటారు. డౌ టైల్ జాయింట్. సార్ ఇదేం సార్ మీరు కొత్తగా చెప్తాను ఏం సార్, ఇప్పుడు డౌ టైల్ జాయిన్ అంటే ఇప్పుడు మీకు చూపెడతా డౌ టైల్ జాయిన్ ఎట్లుంటుందో చూపెడతాను. డౌ టైల్ జాయింట్ అంటారు దీన్ని. ఇప్పుడు ఒక వేళ్ళలో పెట్టినాం అనుకోండి ఇమేజెస్ ని, ఇమేజ్ చూపెడతా డౌ టైల్ జాయింట్ ఇమేజెస్. సో దాన్ని ఇది పట్టు బాగుంటుంది దాంట్లో. ఇవి డౌ టైల్ కనబడ్డాయండి డౌ టైల్ జాయింట్.
ఓ కనిపించే సార్.
ఎట్లా ఉన్నది వేళ్లతోనే చూపెట్టండి, ఒక వేళ్ళతో జాయింట్. So dovetail joint this is called. So సార్ ఇది లాఫ్ ఇన్సూరెన్స్ లో వస్తుందా సార్? రాదు. కానీ సందర్భం వచ్చింది కాబట్టి మీకు చూపెడుతున్నాను.
సార్ ఒక చేతికి ఇంకో చేతి వేళ్ళు పట్టుకుంటే ఎంత స్ట్రాంగ్ గా ఉంటాయో గురు శిష్యుల మధ్య అలా ఉంటే
దట్ ఈస్ ద డౌట్ జాయింట్ అంటారు. ఇక్కడ ఇందులో ఏమేమి చూస్తున్నారండి మీరు?
అన్ని జాయింట్స్ సార్.
సార్ ఒక్కసారి అతుక్కుంటే ఎడిపోవు సార్.
ఇక్కడ ఒక ఇన్స్ట్రుమెంట్ కూడా ఉన్నది, చూసారా అండి? ఇక్కడ కార్పెంటర్ ఇన్స్ట్రుమెంట్.
పులి
కింద.
సార్.
ఇంగ్లీష్ లో చెప్పండి సార్. మీరు ఇబ్బంది పెట్టకండి సార్.
లేదు సార్, తెలుసుకుంటా చెప్పండి సార్.
చిజిల్. ఉల్లిని ఏమంటారు? చిజిల్ అంటారు. మీకు ఇప్పుడు మాటతో చెప్పాను, నేను చూపెడతా, ప్రాక్టికల్ చూపెడతా. చిజిల్, CHES, చెజిల్, IL, చెజిల్, చెజిల్. స్పెల్లింగ్ కొంచెం చిజిల్. ఇది చెజిల్. కనబడ్డా అండి?
ఎస్ సార్.
స్పెల్లింగ్ CHISEL, చెజిల్. కనబడ్డా అండి? ఎంత మోడల్ ఉన్నాయి చెజిల్స్? That means if a person lose my class, he lose many things. Not only insurable interest and insurance details, not insurance, the TP details, the Transfer Property Act details, then how it can be transferred, that you lose the many things. So the new words that you learnt is dovetail joint, and another is chisel. Yes, that is the instrument used by the
క్లాస్
వుడ్ వర్క్ సార్.
స్టడీ.
అది యాక్చువల్లీ ఐ వాంట్ దట్ ఏ కార్పెంటర్. సార్, ఈ బ్లాక్ స్మిత్ కూడా చెజిల్ యూజ్ చేస్తారు సార్. ఎస్, బ్లాక్ స్మిత్ ఆల్సో యూజ్ ద చెజిల్ టు కట్ ద రాడ్స్. ఎస్, మరి గారి వాడు కొట్టేది మాత్రం చేతును కొట్టాడు, రెండు చేతుల్లో కొట్టేది సమ్మిట ఉంటది. దాన్ని ఏమనాలా? ఆల్రెడీ చెప్పిన మీకు. రెండు చేతులతో కొడతాడు. కొడితే వీడు చిజిల్ ఇక్కడ పట్టుకుంటాడు. ఎవరు? బ్లాక్ స్మిత్, అంటే ఐరన్ స్మిత్. స్లెడ్జ్ హ్యామర్ అండి అది. ఆర్ యూ ఫాలోయింగ్ మీ?
ఓకే సార్.
Yes. So in the tomorrow class that I would like to deal the contingent interest, please read it and then you come to the class. Let me make our class as a participatory class. So that is what I want to from you. So with this, I would like to close down, and please inform the other people also that my class is there from the 3:15 to 4 o'clock. If I don't take the class, I will inform you in advance. Otherwise, presumption is my class is there. Presumption is my class is there. Unless until I say there is no class tomorrow. So continuity would be there. With this, I would appreciate your, thank you very much for your patience listening. And we will see again tomorrow at 3:15 exactly. Then up to that extent, let me take your leave. And here I said thanks by Professor Dr. Muhammad Saib Hussain, a voluntary online class professor of law. So this is with now exactly now it's the 4 o'clock. I would like to wind up. Then we meet you again tomorrow. We read the contingent interest. Then come to the class. Let me make the class as a participatory